Thank you. All right. My name is Nick Blessing, and I am an attorney in Kansas. I represent tenants when they're facing eviction court and when they are having other kinds of issues with their landlord. And giving this presentation with the Kansas Green Party, what we're going to be talking about here is kind of what um, things to know and things to think about when people are facing these kind of issues, like when a landlord is refusing to make repairs. Um, I'm going to talk about eviction procedure and kind of certain things that are the really important things to focus on and to prepare for if you're a tenant and if you're facing eviction. A big one is eviction notices that landlords give prior to filing the eviction. I'll talk quite a bit about that. Um, and then, kind of, what this is meant to be is the first step in tenants really getting together and organizing themselves. So I think the first thing we need to know is what are our rights under Kansas law, and kind of understanding that really there are some laws in Kansas that are really good for tenants, but they just don't really get enforced. And the main reason why is because tenants do not have representation in court. It's one reason why a right to counsel in Kansas would be for tenants facing eviction would be huge and would be a huge game changer. So I'll get right into this. So the landlord is refusing to make repairs. What can a tenant do? So Kansas law does require landlords to comply with requirements of applicable building and housing codes materially affecting health and safety, and they must maintain in good and safe working order and condition all electrical, plumbing, sanitary, heating, ventilating, and air conditioning appliances, including elevators supplied or required to be supplied by the landlord. So essentially, the first step is if there's something in your house or apartment that needs to be fixed, the first step is to notify the landlord in writing. And all communications with the landlord really should be in writing. It is fairly common for people to have pretty casual relationships with their landlords, and they're making a phone call or speaking, verbally in person, and that can be okay, but it should be followed up with a written communication. But the whole point here is, um, this could be the beginning of a legal dispute, and it could be something that could be brought up as a counterclaim if it never gets dealt with, if a tenant ends up facing eviction for another issue, or possibly could be facing eviction as retaliation for complaining about needed repairs. So yeah, the first thing is everything really needs to be in writing. But what are the actual remedies that the Kansas Residential Landlord and Tenant Act gives tenants? So basically, there's two options. The first is that a tenant can break a lease because a landlord is not making repairs. Um, this is only really advisable to do, and in a lot of cases, it's not going to be a good option, because if you're going to break the lease, you got to have somewhere to go. And a lot of times people aren't going to have somewhere to go. But if you can give what's called a 1430-day notice. And this is just an example here of one that basically the idea is you're telling your landlord, hey, this is what needs to be fixed. You need to fix it in 14 days, or at least make a good faith effort to initiate fixing it within 14 days. And if you don't, this lease is terminating in on the next rent paying date that's at least 30 days away. So, for example, today is is June 8th. So if you gave a 14 30-day notice to your landlord today, and if your rent is due on the first of each month, you'd be terminating your lease on August 1st if the landlord doesn't make the repairs. But a lot of times, and this is where I see a lot of my clients, that's not going to be an option. So they really can't just leave. They really can't just break their lease. So what you do is, and now what a lot of people will tell you is you cannot withhold rent in Kansas. I kind of disagree with that, but as a practical matter, you really shouldn't, because if you withhold your rent, your landlord is going to or may give you a 3-day notice for non-payment of rent. We'll talk about those later. But what you could do is you can pay your rent and you can essentially say, give them this type of notice. It doesn't have to be in this specific form, but basically the idea is, hey, I'm paying you this rent now just so you won't give me a 3-day notice, but I don't think you're really entitled to this. And if we end up in court for some reason, I am going to want this rent, or even at least a part of this rent, to be paid back to me. And so, because tenants are entitled to damages if the landlord refuses to make repairs, it's a residential lease is both a contract and it has statutory requirements. And as I explained before, it is a statutory requirement that the landlord maintains everything in your apartment. The only thing is, like, if you break something, if you're misusing something, then you would be responsible for the cost of repairing that. But otherwise, the landlord is responsible for it, and the landlord is violating Kansas law and breaching the contract that you have with the landlord, and you are entitled to damages. And the primary measure of damages is the amount of rent you're paying compared to how much that apartment is really worth with those defects. And that there is case law discussing this, even a recent decision by the Kansas Court of Appeals that says that is the primary measure of damages. In addition, if you incur any expenses, like sometimes, for example, heat doesn't work, you buy a space heater. You're entitled to damages for the cost of that space heater plus the reduced value of the rental unit. And now, like I said before, tenants usually don't have money to pay a lawyer. And as a consequence of that, we live in a capitalist economy. There aren't really private attorneys that do this stuff. There's some exceptions, but very few. Usually, if people are getting assistance from an attorney, it's probably from legal aid. But they can sue their landlord in small claims court. And the statute of limitations for a written contract is 5 years. Or if it is an oral lease, the oral leases are allowed in Kansas. It is possible to rent a house or apartment and not have a written contract. There, the statute of limitations is 3 years. But so basically, any time within that statute of limitations, a tenant can file in small claims court. And the monetary limitation in small claims court is $10,000. Additionally, so like I said before, a tenant's entitled to damages if a landlord won't make repairs. And when I say damages, I mean money. Sometimes I'm in legal speak mode all the time. That's the problem with being a lawyer. But additionally, a tenant could have other claims arising out of the same facts. And one is, say you moved in and there's problems with the place when you moved in. Like you move in and the dishwasher doesn't work or the air conditioning doesn't work. And the landlord does not repair it after you notify them. And I mean, really, if you're moving into a place, they just like gave you the keys to the place, they should know what the condition is of that. No serious person using their common sense thinks that that landlord has any real argument to say, "Oh, I didn't know that, the heat didn't work or the AC didn't work." That's ridiculous. They should know what the condition is of the apartment that they give you possession of. But so what I'm getting at here is you can actually break the lease even earlier than giving the 14 30-day notice if you are given possession of an apartment that is in a defective condition, not complying with some code. You have a question? I'll get to that. So I'm not worried about that. So just to what you do here is this is a 5-day notice. You give a 5-day notice and you move out. You have to give the notice within 5 days after you move out. And then the lease terminates as of the time that you vacate. And they have to give you your security deposit back. Now, yeah, there are, and this happens, but here's the nice thing about the Kansas Residential Landlord and Tenant Act. There is no such thing legally in Kansas as an as is rental. You cannot contract to say, I'm accepting this apartment and paying rent for it with these defective conditions. It's not possible. It's not legally possible. It is illegal because the Kansas Residential Landlord and Tenant Act says that those terms, those provisions of the law cannot be waived by the parties. So no such thing. And it doesn't. And if the move in checklist says something that isn't true, I'm not worried about it because the best kind of evidence really is photographs and maybe reports from code enforcement if that can be done. But here I'm not even talking about what you might be entitled to. This could lead to a legal dispute because I think a lot of people actually don't know that they can do this. Because what could happen is the landlord might say, "Oh no, you can't break the lease like that. You still have to pay this rent. I'm not giving the security deposit back." Um, if they filed an eviction case based on that, if the tenant has representation, I wouldn't be worried about this at all because this really, I mean, it's set out in the statute. Now the problem is, um, the problem we really get to here is that tenants do not have um, representation, and they're up against a landlord in court, and they do have representation. A lot of judges don't really take pro se litigants, unrepresented litigants, seriously. Um, and that's a huge problem that we have. And that's why, if you can't have representation and if you're going to be suing the landlord, small claims can be a good option. Um, However, if the landlord sues you, um, there's going to be some issues, and we'll get to that. But like what I have right here is if you have a legal dispute with your landlord, you really should contact Kansas Legal Services. You can get free legal advice if you qualify for their services. Typically, people whose income is 125% or under, or 150% of the poverty level or under. And so that depends on what your income is and how many people are in your household. The more people in your household, the higher your income is. But you should apply for services, and you can get some advice at the very least. Um, Now, when people are facing eviction, this can be really difficult because there are lots of eviction cases filed every day in Kansas. Um, and the Kansas City area is no exception. The Wyandotte, Johnson, and Leavenworth counties, there are lots of eviction cases, and in many of them, there are much more issues present than just the landlord didn't get paid their rent. However, the way a lot of these cases get treated is, oh, landlord wasn't paid rent. Okay, tenant's evicted. Like, essentially, that's how it goes. Not always, and even when they're not represented by attorneys, they're like, eviction cases do get dismissed. But it's just kind of rare. And really, the way that this procedure is set up, as I'll explain, one of the problems is how fast the eviction procedure is in Kansas. If it's a non-payment of rent case, the landlord just has to give you a 3-day notice before filing a case. And I mean, if you think about that, like, that's crazy, because like, if you can't pay the rent right now, what's the chances that you're going to be able to pay it in 3 days? And what's the chances that you're going to be able to completely move out within 3 days? And that, if you work, that's probably going to interrupt your work schedule, lead to even more, you losing even more money. Um, it's a huge burden, but this is the law, and there's really no, it, I think it's inherently unfair, but it doesn't seem that there's, that just the legal system itself. Nobody's going to challenge this statute, and the Kansas Supreme Court's going to overturn it as unconstitutional or something like that. But then after that, the first appearance is called, we call it the answer hearing. It has to happen within 3 to 14 days after the case is filed. And all that tenants really have to do is they just have to show up. Um, and then a trial will be set, and the trial can be no later than 14 days after the answer hearing. So we're really talking about a period of 1 month at the most for most of these cases, which is very fast for compared to any other kind of lawsuit. That's very fast. And there is no way to slow down the process for tenants. Normally, in most cases, you can request a continuance if you need more time to collect your evidence and things like that. And there is evidence, especially if there's a situation where the tenant has a counterclaim, there is evidence to be collected. And a lot of times, tenants can rely on pictures, but if we're talking about needed repairs that the landlord violated their duties, but you can't get a continuance, because in order to get a continuance, you have to pay a bond into court. So it's essentially like tenants are assumed to be, like, it's assumed that the tenant should be evicted. It's assumed that the tenant has no real defense, has no real claims against the landlord. Um, and it kind of contradicts other usual discovery deadlines, because in limited actions court, which evictions are in, um, there's a 14-day deadline. But if you just had your answer hearing and your trial, in many cases the trial will be set a week later. You're not going to be able to get a continuance most likely, especially if you're unrepresented. Now, what I like to make clear to people is, when is it that the tenant actually has to leave? Because a lot of people are a little bit confused about, at least the clients I have sometimes, is when's the point that you're actually going to be removed if you're facing eviction. Now, the point is basically once an eviction judgment has been entered. Now, that could happen if the answer hearing is held and you don't show up, or if what happens many times, people show up but they just admit that they did not pay the rent, and then that's it, and then their judgment is entered against them. And then there's a separate order that gets filed along with the journal entry of judgment, the eviction judgment. That's called a writ of restitution. And that is what gets sent to the sheriff. And then the sheriff comes to the tenant's residence and tells them to leave. And it's essentially like, okay, you've got 10 minutes. And now that could the sheriff could come basically anytime from about 7 to 10 days after the judgment is entered. So going back to the timeline, a maximum of 14 days after the case is filed is the answer hearing, and then a maximum of 14 days after the answer hearing is the trial. And then it's basically a maximum of 14 days after the trial is when the tenant will actually be removed. I usually say it's probably going to be about 7 to 10 days, but it really can vary, and sometimes it can take the full 14 days. But it's a it's kind of a stressful situation. I mean, it's a super stressful situation because you don't actually know when they're actually going to come. But basically, if you're in the situation where the eviction judgment has been entered, you've got to get your stuff out as soon as possible, because when the sheriff comes, your stuff that's still in there will be locked inside, and you'll basically be at the landlord's mercy as to whether you'll be able to get that stuff back. So another slide on the writ of restitution, basically what I already said. So, and this kind of reiterates also what I already said, is you got to appear for the answer hearing and you got to appear for trial. And then you have to either win at trial or make an agreement with the landlord. And that can happen, and that can be okay sometimes, but that is the only way to at least delay or possibly avoid the writ of restitution being executed and you being removed from your unit. So, being late on rent. So being late on rent, unless your landlord is going to later accept it late, this is can be a point of no return for people. Rent assistance, it's possible to get it in, but many times it's few and far between. United Way, Catholic Charities. Also, just did a little bit of searching online. I found this Metro Lutheran Ministries. There's other churches that also provide rent assistance. I think many times it's only for their congregants, but there are sources out there, but it really can be difficult to get your hands on. But absolutely, like, you need to be in contact with a lawyer, and if you're not able to hire an attorney, then you need to apply for Kansas Legal Services. Um, but like I said, it's possible that the landlord will just accept the rent. I mean, for some landlords, they might not even want to go through the trouble of dealing with evictions, but some of them they just do it routinely. They've got a lawyer that they have file lots of evictions for them, and it's a routine process for them, and they don't blink an eye about doing it. But um, so basically, the rule is you get a 3 day notice. You've got to pay within the 3 days or vacate within the 3 days. And if you don't do either, the landlord can file an eviction case. Some people this might seem obvious, but you're going to want to save that notice. There could be something wrong with it, and this could be the basis for a defense. And if you're going to be speaking to an attorney and getting legal advice, you're going to want to be able to show that to that attorney. That should be the first thing that you have available. Now, say the 3 day period passes, you can attempt to still pay the rent. And the landlord can accept it, although the landlord can refuse it after the 3 days, and they can say, no, we're going to evict you. But now this comes with some risk. You can try to pay it, and if they accept it without without reserving their rights to still evict you. This is something that the Kansas Landlord Tenant Act provides. If they accept it without reservation, they can't evict you for it. And this isn't super clear, but arguably, even if it's a partial payment, you may have a defense that would prevent them from being able to continue evicting you. And it kind of almost sounds like, well, if they're going to accept a payment from you, why would they be pursuing an eviction case? I see it all the time. It's ridiculous, but it does happen. Now, not all evictions are for non-payment of rent. Some of them are filed because there is uh, allegedly another violation of the lease by the tenant. Uh, now, this could be like, say, you damage something and wouldn't pay for the repair, and like it really was, or they're accusing you of it being your fault. I've seen that happen before. Or say like you have an unauthorized occupant in your unit, or it really could be almost anything other than non-payment of rent. um, the landlord can give a 1430-day notice. Now, this is similar to the 1430-day notice that a tenant can give, and basically the notice is essentially, this is what you did to violate the lease. You've got 14 days to cure the breach, and if you don't, the lease will terminate in 30 days. Um, Now, you need to get in contact with an attorney as soon as possible. And that might be through legal aid, or it might be through a private attorney. Whoever it is, you need to be talking to an attorney. You have to make a plan to respond to the 1430-day notice. You must respond in writing. And it could, and it's very fact specific. Um, your response could be like, say you actually did do something to violate the lease. You just like make a plan for what you're going to do to fix what you did. Like, say for example, you did damage something. It's like, okay, I'm going to make this payment, and I'm going to make another payment on this date, or something like that, for example. And you put that in writing. And essentially, and that's your evidence that you made a good faith effort, because you don't have to completely cure the breach. You just have to make a good faith effort to initiate a remedy to the violation of the lease. And that would be a defense because Kansas law says if you initiate a good faith effort, the lease will not terminate. So, talking about kind of going over some of the same ground again, but the types of eviction notices that they are. So like I said, 3-day notice to pay or quit, 14 30-day notice of a lease violation other than non-payment. And then also if you have a month to month lease, uh, this only applies if you have a month to month lease, and you could have a month to month lease. Most of the time people have a month to month lease if they move into a place and they sign a 1 year lease and then it expires, but you continue living there and continue paying rent, and it's essentially you've rolled over into a month to month tenancy. But if you are a month to month tenant, either the tenant or the landlord can give a 30-day notice at any time to terminate a month to month tenancy. So here, actually. Now, but, and a lot of landlords do mess this up, the notice must state that the tenancy will end on a rent paying date, not less than 30 days after receiving the notice. So, for instance, today is June 8th. July 1st is less than 30 days away. So, if either a tenant or a landlord gave a month to month termination notice today, they could terminate the lease effective August 1st, assuming that the rent paying date is the first of the month, which most leases it is. Now, some kind of general information about eviction notices. So, and I only say this because I have had clients confused about this. An eviction notice isn't a court order. It's not a court document. It comes from the landlord. It doesn't come from a court. It's what happens before courts get involved. And it's not to be confused with an eviction summons. An eviction summons is the court document that is served on you after the eviction case is filed. And yeah, like I said, this is what's required to be served on the tenant by the landlord before the eviction case is filed. And it has to either be handed to you or left on your door, or it can be mailed to you. Now, but if it's mailed to you, they have to give you 5 days instead of 3 days for a non-payment of rent notice. And yeah, after that, the landlord can file the eviction case. And for the answer hearing, you have to show up and you have to deny the allegations in the petition. And you have to assert any defense or counterclaim that you have. So just list here of possible defenses. If there was no notice, or if the notice was defective in some way, it possibly could. Sometimes landlords give the notice and then they file the case before the time period for the notice expires. That's a defense. They cannot do that. They have to wait until the notice period is up. And if they do that, they have to dismiss that case and then they have to file a whole new case. If the landlord accepted the late rent without a reservation of rights, if they do that, that reinstates the lease, and the landlord cannot evict you. If they don't end the month to month tenancy, notice on a rent paying date, or there could be some other way that it doesn't comply with Kansas law. Sometimes I've seen notices that demand that the tenant pay the rent, but it doesn't say to leave. That's a defective notice. It has to give you 3 days to leave. And that seems stupid and it seems like obvious, but it happens, and that means that the eviction case has to be dismissed. Um some other possible defenses are retaliation. If the landlord, like I discussed at the beginning, where the situation where the tenant can give a a 5 day notice to terminate the lease, you move in and stuff needs to be fixed. Um, if you end up still living there, rent abates at the start of the lease term. That means that you don't have to pay the rent, or at least you don't have to pay the full rent. But if you end up in a non-payment of rent case and you have those facts, well, you can say, well, I don't owe that rent because I've been paying all this rent before this rent became due, and I deserve some of that rent back. Um, sometimes the wrong person files the case, and that sounds kind of crazy, but it happens. Sometimes the landlord is a company, but the wrong company files the case. That's a mistake by the landlord's attorney, but it happens. I've seen it happen. I've gotten cases dismissed by it, because of that. Also, if the property is a HUD subsidized property, and it's basically any kind of federal uh, subsidized property, maybe not every kind, but most of them, they can't give a 3 day notice. They have to give a 30-day notice. Mhm. Well, so there's some arguments about that, and there's no Kansas Court of Appeals or Supreme Court case that deals with this, but there are cases in other states, and there's been different findings by different courts. But what a lot of landlords do is they'll give a 3 day notice to pay, but 30 days to leave. Now, any tenant's argument would be like, no, you got to give 30 days to pay. This is from the CARES Act from COVID, but that's but basically the important thing is some landlords can't just give 3 days; they have to give 30 days. Now, also, if the landlord now possible counterclaims, if the landlord has caused an interruption of utilities, and this does happen sometimes, uh, that entitles the tenant to 1.5 times 1 month's rent or their actual damages. Also, if the landlord has unlawfully removed or excluded the tenant from the residence, that entitles the tenant to 1.5 times 1 month's rent or their actual damages. And by this could be literally the landlord took the tenant's stuff and threw it out, and that does happen sometimes. Um, that's a counterclaim, or it's any of these would be a basis for the tenant to file a case against the landlord. um, Unlawful entry. Some landlords are required to give reasonable notice prior to entering a tenant's apartment. Generally, we consider that to be at least 24 hours notice, and it has to be for a proper purpose, like making repairs or showing it to a prospective tenant or buyer. Um, but they also can't abuse their right to access in a way that effectively harasses the tenant. This
this would give a tenant a basis for a claim for unlawful entry, which they, are would be entitled to any actual damages, or they can get injunctive relief, ordering the landlord to cease the unlawful conduct. Um, or like what I talked about at the beginning, landlord's not making repairs, that's counterclaim. And you take the reduced value of the rent that was paid, um, and you multiply that by the months that the defective conditions have remained, plus any expenses that the tenant has incurred. Failure to deliver possession is a big one because this is where the landlord hasn't made repairs, and the things that need to be repaired have been there since the tenant moved in. So you've got your claim for damages and injunctive relief, ordering the landlord to make the repairs and granting the tenant damages. But then additionally, because the landlord failed to deliver possession of the rental unit at the beginning of the lease term, that's an additional claim, and the tenant can get 1.5 times their actual damages as a separate claim. So these claims, they stack on top of each other, and you add them up, and a tenant could be entitled to thousands of dollars. Yeah. Arguably, at the very least, now um, it would be a violation of the on number 4, violation of the landlord's duties, to make repairs, because that's one of their duties, is they have to provide hot water. That is so so they would definitely have a claim for that. And I would also include, and on interruption of utilities, what I call that is willful diminishment of services. Um, so I would claim for both, and I would do, um, the reduced value of the rental unit, on both of them, unless 1.5 times 1 month's rent is more. Um, mhm, mhm. Sometimes, yeah, I've had cases where that's happened. I had I've had cases where, like, my client got a 1430-day notice, and we and then there were also like things that weren't being repaired, and we got the our accounts on the counterclaim for the failure to make repairs, and for failure to deliver possession, and we also asserted retaliation, but the judge didn't go our way on retaliation, and also found that my clients did what the landlord accused them of doing, which was the basis for the eviction. So basically, both sides were granted what they wanted, or part of what they wanted. But even when that happens, the good thing is, like, these claims need to be raised. But yes, that is a possibility. So, however, what should happen if it's a non-payment of rent case, um, if it turns out that the landlord wasn't entitled to that rent, and the reason is because of the counterclaims, then I would say that shouldn't happen, although it still could, because judges do weird things, and sometimes it does not make sense what they do. Um, but yeah, for sure. I mean, and kind of the result here sometimes is that we'll make a deal with the landlord, like, and that's usually only done if we're, and kind of what the tenant really needs to be aware of is, you go to trial. We don't always know exactly what's going to happen at trial, although sometimes we have a good case, and sometimes we don't have such a good case. And sometimes what tenants will do is they will choose to waive their counterclaim, but then they will not have to pay whatever rent that's they're being accused of owing, and they don't have to leave. It's not always a great result, but sometimes that's what happens. Um, yeah, and then I just got this bit about retaliation here. That retaliation specifically, landlords are prohibited by retaliating against a tenant by increasing rent or decreasing services after either the tenant has complained to code enforcement or complained to the landlord about something that needs to be repaired, or if the tenant has organized or joined a tenants union. Um, if the landlord retaliates, the tenant can sue for 1.5 times the monthly rent. Now, um, and there are some exceptions. Now, if the thing about retaliation is, I think the Kansas statute, it's actually kind of weak, and it's a lot of times retaliation is kind of the thing that a lot of people think about. Um, and I do think a lot of evictions are retaliatory, but the way the statute is set up, it, if the tenant does owe the rent, then the landlord can evict them. Like if it's not, even though it's possible that they wouldn't have evicted them if, even though they owed the rent, they wouldn't have evicted them if they didn't complain about the dishwasher that needs to be fixed. And part of the thing is that there's actually no intent component here. Um, and and what the statute does is it just puts in, if the tenant does owe rent and the landlord did give a 3-day notice and all of that has been met, this doesn't prevent a landlord from evicting a tenant, essentially. Um, so it doesn't, basically, the statute kind of cuts out the consideration that the landlord could have um, chosen, or even if it could be proven that the landlord wouldn't have evicted the tenant if they hadn't complained, and they would have just let them pay the rent late. But instead, because they complained, they didn't accept late rent and they moved forward with an eviction. Yeah, the statute doesn't allow you to do that, which is why I'll put retaliation in there when I'm asserting claims for a client, when I've got a case like this. But the more important claims, I think, are really just the failure to make repairs and failure to deliver possession, if that's the case. Yeah, it could be argued. It could be argued, but it's because what the statute says, because this is actually the funny thing, and increasing rent or decreasing services. Now, if the landlord says, you made me fix this, I'm increasing your rent by $100 a month, you can't do that. That'd be probably the clearest case of retaliation. But decreasing services, what does that mean? Now, that could mean, you made me fix this, so I'm going to cut off your electricity tonight. And you're just not going to have electricity tonight because I can do that. That doesn't happen that much, but we interpret decreasing services as including terminating a rental agreement because, well, if you're terminating a rental agreement, we're not just talking about the electricity or the water or something. We're not talking about one services. We're talking about everything. You terminate the lease, the tenant's losing everything. But a non-renewal, if the lease has not yet expired and the new lease has not been signed yet, and then the landlord gives whatever notice is necessary. Sometimes there's like a 60-day notice thing, or and they say, yeah, we won't be renewing your lease. See, because that would be a new contract. Although you could argue that that's decreasing services. I would just be worried that that might be a losing argument. So some of these things, and especially legal stuff, like we're talking about stuff that might get hashed out in court, we don't actually know what every single detail in every statute means because it hasn't been litigated. It hasn't been there hasn't been a trial court decision that's been appealed, and then the Court of Appeals or the Supreme Court has said, this is what this actually means. And yes, non-renewing a lease is included in retaliation. That probably will never happen, and we can't rely on that. But we can always argue it and use it as leverage for a better agreement, maybe. Um, if that makes sense. So really, that's the main presentation, but the next step for tenants is, I mean, well, we need to know what our rights are, but we also need to organize together, form tenant unions, share information and resources, and work together to support the tenants that are facing these kind of issues. And I think that's what, um, tenants in Kansas really need to, work together towards. Um, and I can, just leave the rest of our time for any other open discussion or any other questions.
You mentioned what's the name? Already canceled.
Yeah, well, it's been suspended for because it's in court right now, right? Yeah. And they have that in Lawrence now also. They've had that for a while. And it's gone to court too, but it's gone the other way. I think the Kansas Court of Appeals, the landlords who challenged it lost at trial court, and the Kansas Court of Appeals affirmed the trial court. Yeah, I mean I mean that's something that we could, do in Wyandotte County or in any city in Johnson County. Um, Now, I don't know if we could do it as a ballot initiative. We would have to look at the local ordinances for whatever municipality we're talking about, because I don't know, because in Kansas we don't have them for statewide. Now it in Lawrence it was passed by the Lawrence City Commission, so it could be done as an organized effort. If ballot initiative is an option, we could do that, and also pressure the governing body of whatever city we might be talking about to do it on their own initiative, because that possibly could be easier, depending on where we're talking about. But source of income discrimination is a real problem. It's really difficult for folks who have vouchers to find a place that will accept the voucher, and a lot of times they have to go to places that are shitholes. Like a slumlord that will accept a voucher. Um, now, but I think right to counsel is a real game changer, and they are also talking about doing that in Lawrence. And now there's a group in Lawrence Tenants, and I'm not super familiar with them, but they've done some good work in the Lawrence area, and we could we could take a page out of their book as well. But they are part of a group that is, I think there's a couple or other organizations or a couple other people involved, but they're trying to push for right to counsel in Douglas County. But if we had right to counsel, it would be a complete game changer, because when tenants are represented in court, the possibilities for them to avoid eviction is so much higher. Like it is like it's easier to get a better agreement, and also it changes the dynamic, because we have a dynamic where basically landlords can just steamroll the tenants. They don't like their costs of filing all of these eviction cases. I mean, for the fact that they're filing all of these lawsuits, their costs are pretty minimal. I think a lot of the landlord attorneys, I don't know how all of them do it, but they're not charging by the hour. They're like doing like flat fees. Like, I don't know, probably maybe $300 or $500 or something like that per eviction, because and they do that because so many of them, all they have to do is file a petition and show up in court and ask for a default, because a lot of tenants don't show up for the initial hearing. I think a lot of people are don't show up because they're scared, or I mean, a lot of people work. So I mean, like if you got to go to court, and court's always like in the morning, like at 8 to 10 in the morning, depending on what county you're in. And yeah, for a lot of people, that means they're going to have to miss work, and a lot of people, like, that's not an option, you know.
Usually, a lot of people, if they go to try to themselves,
Yeah.
they do it without pulling off the costs where their presence is conducted, makes it more like acceptable to a judge, or it's just the fact that they have not.
It depends on the judge too. I mean, because every judge is different. Some are better at dealing with self-represented litigants, and some, it's like they're not even there. But I think probably the important thing is just understanding, like, and you don't have to be perfect at how to present evidence, but just maybe just some familiarity with, like, okay, so, like, you're facing eviction, so they're the plaintiff, so they're going to go first, they're going to present all their evidence, they're going to have a uh most likely the property manager will be their one witness, with some exceptions. And they'll put the lease, the eviction notice. These things aren't anything that you're going to object to. And just, like, understanding, like, a lot of judges can lose patience with people because people are in court and they don't know what they're doing and they're, like, interrupting sometimes. And it's just like, your turn to talk is now, you can I mean, there's so much. It's difficult because there's so much. After they ask the property manager all the questions, then you get to ask the property manager questions. And now, it might not even be beneficial to do that. And really, the important thing is you'll have your turn to talk and present your evidence. And you're going to, say, you're going to present evidence about the oven that doesn't work. And, Your Honor, I submitted this maintenance request on this date, to the property manager. I did not receive any response. They did not ever fix this issue. Um, you know, I've got here a picture of the oven that does not work. This is Exhibit A. Um, I mean, there's so much. It's really difficult, and it's one reason why, man, it's way easier to just have an attorney, because if you have an attorney who is is just used to doing this, like, it wouldn't. It's like, if I'm representing somebody and I just have the exhibits and I know what the facts are, I can direct the testimony, and I always practice it with them ahead of time. That's a good question, though. Actually, that's something I should think about some more. Yeah.
I just want to rephrase what you just said.
What?
Is it more like the lawyer will be able to challenge the statute or what the statute is looking?
Well, I'm never really challenging a statute. Um,
Or at least limit the evidence pertinent?
right. Well, so, I mean, the tenant can present the evidence
Sure.
without an attorney. I mean, you're basically doing it through your testimony,
Right.
um, and just explaining to the court, what's everything that happened. Um, yeah, of course.
There were being able to get a settlement,
Mhm.
like the one. Do they figure in the security deposit with those?
So
Because
security
I never
deposit.
got a number for that, and never did- why didn't get security deposit back?
Now, we should do another one of these again, and I can talk about security deposits too. Because, yeah, so security deposit doesn't become an issue until after the tenant moves out.
Yeah.
Now, a lot of times, if there's an agreement, yeah, and if it involves the tenant moving out, the security deposit should be discussed, should be part of the agreement. Because, and sometimes, if it's not a great agreement, the agreement might be that the landlord gets to keep the security deposit, or that the landlord will return the security deposit. Um, but that, now, when you've moved out of the place
and you didn't get any reason why, and if it was in Kansas and you weren't given a reason why the security deposit wasn't given back to you, the landlord did not follow the law, because they do have to return the security deposit to you within 30 days. And if they're going to keep any of it, if they're going to keep any portion of it, they have to give you an itemized list of the things that they applied it to. And they can't apply it to anything if it's, we call it normal wear and tear. Normal wear and tear security deposit doesn't cover. And by normal wear and tear, all we mean is something something that's not the result of the tenant damaging or misusing some property in the apartment or house. It's not a result of a violation of the tenant's duties, which generally tenants are supposed to keep things reasonably clean, not misuse anything, not damage anything. Um, uh, but yeah, the security deposit should be part of the discussion if the tenant is leaving. If the tenant's staying, then it shouldn't be. Anything else? A little bit. Yeah, so, and well, I guess I should clarify your question, because the housing authority is involved either as, and if you're talking about the Kansas City, Kansas Housing Authority, so the Kansas City, Kansas Housing Authority has a lot of their own properties where they are the landlord. Is that the situation you're talking about, or are you talking about that they've issued a Section 8 voucher?
Yeah. There's actually that.
Well, the landlord is federally funded because the now they're not otherwise federally funded. Um, but the Section 8 voucher is a federal program. But so the Kansas City, Kansas Housing Authority, I've had lots of run-ins with them, and they now the process for the most part is the same. There are some different notice requirements for them. They have to give a 30-day notice for any eviction. There's never just a 3-day notice from the Kansas City, Kansas Housing Authority. They are required to include some other things in their notices. They have a grievance procedure, in which the tenant can request an informal hearing, and those informal hearings are pointless. They are heard by an attorney who acts as a hearing officer, who's hired by the Kansas City, Kansas Housing Authority, is supposedly meant to be a impartial judge, essentially. But the hearings are a joke. I've had clients who received a 1430-day notice, and then I contacted the housing authority's attorney, and then they said, okay, we're not going to evict them. And then the client was then told that they still have to appear for this hearing, and this hearing officer told them they're being evicted, which was not true. So, and I think it doesn't really serve any good purpose having these informal hearings. The idea should be like, is the housing authority going to move forward with eviction? We're going to decide here. But I mean, really, it's just a rubber stamp for them. It's not. I don't think. I think probably not every case goes the housing authority's way, but still, they're not. The the hearing officer doesn't actually consider any law and doesn't have a really a fair analysis of the facts. Um, and I think that there's some things about the process I think are well, I mean I feel like the process can be discriminatory toward people. Of course, I can't prove that. That's how I feel about it. But for the most part, no. It's they go through the same court procedures once the housing authority files an eviction case. Yeah. Any other questions? Thank you. Thank you.